Hello, this is Mac Pierre-Louis again, attorney at law and mediator. Today, I'm discussing the top 5 reasons parents modify family law court orders. This is a video version of a very popular blog post that I wrote several months ago on yourchildsupportlawyer.com. Please remember, all information on the yourchildsupportlawyer.com blog and on these videos are for educational purposes only and do not constitute legal advice. Now, there are many reasons parents may want to modify or change a court order. The following are, in my opinion, the top 5 reasons. Number 5, to increase child support. It's usually the case that a non-custodial parent obligor will make more money over his working life. So it should be no surprise many custodial parents like the law allowing for periodic increases in child support. Under Texas law, child support can be reviewed to be increased either every 3 years or when there's been a, quote, material and substantial change in either party's circumstances. Number 4, to decrease child support. It's no surprise a non-custodial parent might want to bring his child support down if something happened in his life that causes him to not be able to afford his monthly payments. Such cases happen in Harris County all the time. Third reason, to change possession for more access to a child. Many non-custodial parents seek to modify an order to see their child more often. There are many reasons for this. Perhaps the custodial parent is restricting access to the child. Perhaps the original visitation terms of an order are no longer useful and do not work with one party's new job schedule. Many times, parents get new job schedules that conflict with the typical standard possession order placed in their divorce decree, limiting the quality time with their child. Other times, parents move further from each other, causing unforeseen complications that affect one parent's ability to spend time with their child. But whatever the reason might be, there are a lot of lawsuits requesting a court to modify possession to give one parent more time with their child. Number 2, to change possession to give someone less access to a child. Unfortunately, family courts are clogged with allegations of child mistreatment and abuse. Many allegations are true, some are sadly exaggerated. But parents and sometimes a state entity like CPS has authority and a duty to request a court to modify a parent's access to a child when there is actual or potential harm to the child from that parent. Family courts are filled with lawsuits seeking to reduce one parent's access to their child because that parent acts in ways that significantly impair the child's physical health or emotional development. And the number 1 reason to change an order, to change custody, or known legally in Texas as changing primary conservatorship. Let's face it, not all mothers and fathers agree on how to raise their kid. When parents are separated, the question on where a child should live will become toxic to the point where a judge has to sometimes be brought in to answer the question of who gets physical custody of that child. With primary or sole conservatorship, traditionally comes the right to decide where the child lives, the right to receive child support from the other parent, and the right to typically make the major decisions in the child's life. Parents will fight hard to get the right to raise their child in their home, under their structure, when they believe the other parent is unfit. This is the top reason, to me, modifying court orders to change custody is typically the most contentious, emotional, time-consuming, and costly of all the other reasons to change or modify a court order. Well, that's it for now. If these videos are helpful, please subscribe and follow us. Thanks.